Hello, everyone, and welcome to the first session in this new interview series by the Robotics and AI Law Society. Along the way, I will be interviewing people involved in AI policy, safety, and governance. To briefly introduce myself, my name is Samuel. I am a lawyer by trade and a policy researcher. I think of AI as the most impactful technology for our generation and believe that there is an urgency to finding well-balanced regulation. Today, I am joined by Mr. Tarmio Frei. He is a research assistant and doctoral student at Bucerius Law School in Hamburg, Germany. Tarmio, thank you for joining me today. I pass it on to you. Could you briefly introduce yourself and explain what drew you to research AI regulation?
As you said, I'm Tarmio Frei, research assistant and doctoral candidate at the junior professorship for civil law, IP law, as well as law and digitalization at Bucerius Law School in Hamburg, Germany. And my dissertation focuses on how EU law regulates and should regulate anthropomorphic conversational agents. And alongside that, I also work on video game law, data protection, as well as open source hardware. So basically all areas that connect my legal interests with things I am passionate about in my private life. So how did I get into AI law? When I started studying law, I knew that I wanted to work on topics that I genuinely care about. And being a long-time tech nerd and gamer, IT law was sort of the obvious choice for me. But ironically, I initially promised myself that I would never write about AI, simply because there are so many brilliant AI law scholars in the space. So I wasn't sure if I could contribute anything meaningful to the debate. That changed a few months ago. During lunch break, I had a conversation with my friend Greta Spaczynski, who is also a co-author of the blog post we are discussing today. And we talked about a documentary on people forming deep emotional bonds with AI chatbots, basically treating them as romantic partners, friends, or mental health professionals. And that raised a lot of questions. If people treat these systems almost like conscious beings, how should the law react to that development? And when I started looking at the AI Act, it became quite clear to me that the framework doesn't really capture the risks and relational and societal dynamics around these anthropomorphic systems. And surprisingly, I didn't find a lot of legal scholarship on that. So I felt there was a real gap that I wanted to explore. And that curiosity basically pulled me into the field and ultimately into AI regulation more broadly.
Perfect. And I'm glad to hear that you took the jump and did start, writing about AI and these topics, which are so relevant today. As you mentioned, today we're going to be talking about your blog post that you co-authored. It's called Leveling Up Regulation When the Chat Act Enters the Game. Could you briefly summarize what the blog post is about? And then also just talk a little bit about why US lawmakers eventually what prompted them to propose the Chat Act? What problems are they trying to solve?
Sure, of course. So our blog post, which I have written together with Dr. Ingemar Karthäuser and Greta Spaczynski, looks at how the proposed US Chat Act, one of the first federal attempts at regulating AI companions, might impact the video game industry on a national and international scale. The goal of the Chat Act is quite sensible. It basically aims to protect minors from potentially harmful AI companion interactions. But when you take a closer look at the law, its definition of a companion AI chatbot, basically what triggers the material scope of the bill, seems to be extremely broad. Under that definition, almost any large language model-based non-player character, or short NPC, could fall under the law, which might create a real risk of imposing disproportionately heavy and expensive compliance burdens on game developers. And that even where the AI character is relatively harmless and purely gameplay driven. So what we basically argue in our blog post is that the Chat Act doesn't clearly distinguish between low-risk gameplay-focused video game AI companions and the much more complex emotional video game AI companions that basically can genuinely influence users' feelings and behavior and encourage long-term human-AI relationships. And that lack of nuance matters quite a lot because the regulatory needs for those two distinct categories of video game AI companions are very different. But I'm sure we'll get into the details later in the conversation. Let's also briefly talk about why the US lawmakers proposed such a provocative approach towards regulating AI companions. The bill was introduced by John Husted, Republican senator for Ohio, in light of several self-harm and suicide cases linked to AI companion interactions. I believe in a press statement, the senator specifically referred to the tragic suicide case of a 14-year-old teenager that was linked to interactions with an AI companion on the platform Character.AI. The chatbot role-played as a female Game of Thrones character, if I remember correctly. And right now, the case is being litigated in the Florida District Court. It raises a lot of questions on product liability law. I believe there's a Rails blog post actually on that case. And it becomes sort of the central example in the political and regulatory debate surrounding AI companions. And against that tragic background, the Chat Act tries to address a fairly intuitive problem: children engaging with emotionally responsive AI systems that can produce harmful or inappropriate content. And what the bill mainly tries is to prevent children from engaging in sexually explicit chatbot interaction, and it requires operators to implement quite comprehensive age verification obligations as well as other safety measures. So to sum it up, the Chat Act reflects a growing concern that highly personalized AI companions might influence vulnerable users in ways that existing AI and non-AI frameworks don't yet really account for. And it's only one of several proposals on federal level. So there's a lot more debate going on right now.
Yeah, that makes a lot of sense. Thank you. So going into the specific, you just mentioned the definition of AI companion that is brought up, AI companion chatbot brought up in the bill. The bill defines it specifically as any software-based artificial intelligence system or program that exists for the primary purpose of simulating interpersonal or emotional interaction, friendship, companionship, or therapeutic communication with a user. So you mentioned that this is a very broad definition. In what sense do you think there is? In what sense do you think it is too broad? How could they have narrowed it down to better protect children? And do you think that there was like some intentional overreach by the proposal, or is it just imprecise drafting from maybe a lack of technical knowledge or industry knowledge?
I believe it's quite difficult to say why the definition is how it is, but the problem is mainly the term interpersonal interaction, because commonly the term is used to cover virtually any verbal or non-verbal exchange between individuals. And if you adopt this broad understanding in the legal context, almost any generative AI that is capable of a natural language communication, even if it's a relatively simple or gameplay-focused video game NPC, could be considered a companion chatbot. And that, in gaming contexts could include everything from emotionally responsive AI characters like AI boyfriends in games like Love and Deep Space to gameplay-focused teammates like Fortnite's Darth Vader. Besides the gaming context, it might also cover language learning chatbots that leverage LLM technology. So it's a very broad term. And in my view, it's very unclear whether this broad term was used intentionally or not. The main problem for lawmakers is that there is no universally accepted denominator for what we mean when we call an AI our companion. If you look, for instance, at states like California or New York that already have AI companion-specific regulations in place, the definitions for what constitutes such a companion differ quite significantly. At least what unifies those approaches is that they mainly target anthropomorphic conversational agents that sustain simulated human or human-like relationships with users across multiple interactions and can meet the user's social needs, for instance, by engaging in unprompted emotional questioning or engaging on matters that are personal to the user. So what we can see in other US jurisdictions is that companionship definitions usually aim at systems that encourage long-term human AI relationships and could simulate human core relationships. So under these views, most video game AI companions would not be covered. Now, I believe there is at least room for such a restrictive interpretation under the Chat Act as well, because courts could construe the law as also targeting only AI systems that form long-term emotional or social bonds or produce sexually explicit outputs rather than all LLM-driven chatbots. Such a restrictive interpretation would fall in line with the cases that inspired the bill in the first place, such as the Character.AI suicide case, and it would fall in line with the approaches adopted in New York and California. But of course, the language of the bill is quite broad. It leaves a lot of uncertainty whether really it is meant more restrictive or more broadly. And at least one could also argue that it was intentionally drafted that broad so that it would cover as many LLM-driven chatbots as possible to ensure that children are always protected when interacting with AI systems. So I believe this uncertainty is what is the key challenge for game developers and the broader AI industry if the Chat Act actually becomes law.
Yeah, that makes total sense. And I agree that maybe we shouldn't be letting courts at the end of the day like define the policy, right? Like it should come out as the law like properly defined and not like handing it over to the courts to say, hey, please define this properly and please like limit it to where it actually wants to be limited. If this broad interpretation prevails, what do you think compliance, like the compliance process would look like for game studios? And also what kind of information would users have to share in order to play?
It's actually not that easy to answer, but maybe to briefly outline the compliance requirements. The obligations that video game companies would be faced with would change quite dramatically. The first step isn't that problematic. Every player would need to register an account before he could interact with the video game AI companion. So that is not really an issue because right now most games already require players to have a user account. So the real challenges appear at the subsequent steps, because video game studios would have to implement a commercially available and reasonably accurate age verification method. And right now, the proposed law does not outline what exactly meets that threshold, how exactly this age verification process could look like. But given the intention to really protect children, it is likely that simple checkboxes or self-attested ages are not enough to comply with the law. Likely, it means that video game companies would have to conduct age verification based on government ID checks or biometric verification or potentially behavioral analysis. We can actually see some chatbot providers already sort of analyzing the texting patterns of users to check whether the users really are above 18. So this obviously is quite expensive for video game companies to implement and could raise some privacy concerns. And what is also important to note is that video game studios would have to freeze all existing accounts if the law becomes effective, and can only unfreeze them once the users have completed this age verification process. So not only new accounts would have to be verified, also every pre-existing account would have to undergo this verification program. And the law also stipulates quite comprehensive data protection layers on that regard. The age verification data would have to be stored in a safe and confidential way. Information should be limited to what is strictly necessary for age verification purposes, and parental consent. I get into that later on. And of course, you would have to implement technical and organizational safeguards to prevent, for instance, data misuse or data breaches. And the obligations of the video game company would sort of multiply if the age verification process confirms that the player is a child. In this case, the user account would have to be linked to a verified parental account. So this video game studio would have to obtain parental consent before the child can access any video game AI companion features within the game. And if one of these interactions with video game AI companions entails conversations about suicide or self-harm, the parents would have to be notified. That is one important sort of content moderation aspect. And the other one is that, and I believe that makes a lot of sense, children should be prevented from engaging in sexually explicit conversations with video game AI companions. That's quite logically. Right. And now that is not everything that the law proposes. So we have even more in case of children, because besides active monitoring duties for self-harm and suicide ideation, video game companies would also have to notify parents and players and give them information to crisis hotlines. I believe it's the suicide prevention lifeline hotline that must be mentioned in this notification. And lastly, the Chat Act would also force video game companies to implement repeated pop-up disclosures that the chatbot is not a human being. This pop-up must be reoccurring every 60 minutes for ongoing AI companion interactions. So basically every 60 minutes during gameplay, you would have some sort of pop-up like a cookie banner, and then you would have to click close, or I understand that the chatbot is a chatbot and not a human player. So this would also cause problems because it might affect gameplay immersion and make the game feel less believable. So this is the rough compliance framework that video game companies would have to deal with.
That makes sense. Thank you for answering. It's pretty much like establishing a lot of safety guardrails, as they are called, around the chatbots and around video games. And it does make sense. I do understand your argument that if this is implemented within video games, this sort of can destroy a certain this belief that people might need in order to really get into a video game. And what the law is, who the law is trying to protect is maybe not necessarily being vulnerable within the video game sphere, right? As you mentioned, the Chat Act comes from children interacting with Character.AI and Replica and ChatGPT, which are not the same types of systems as we see in video games, and that is not going to happen with characters like the Darth Vader in Fortnite, which is has a short term and is just basically repeating phrases, right?
Yeah, exactly. I believe the lawmakers should sort of distinguish between different types of AI chatbots and take a close look at where the risks of deep and potentially problematic and risky parasocial bonds actually exist and could lead to a significant harm. And for video game AI companions, I believe that the law should make a distinction between gameplay-focused video game AI companions and emotional video game AI companions. Gameplay-focused AI companions like Fortnite's Darth Vader, which you have just mentioned, are relatively low-risk use cases for generative AI because they are restricted to only reply to comments on in-game events, and they do not have the memory capabilities to foster long-term and potentially problematic human AI relationships. So the risks associated with such systems are, I don't know, the AI giving wrong answers to in-game events, hallucinating quests that actually do not exist. So that could be frustrating from a player perspective, but it's not an actual significant risk. Besides that, occasionally it might be that safeguards do not work sufficiently well, leading the Darth Vader character to insult a player. So that might be another more problematic risk, but it's fairly limited, the risk profile. And with emotional video game AI companions, such as virtual boyfriends, AI-driven boyfriends in video games, the risk profile is much higher because those work quite similar to Character.AI and Replica, and equally aim at fostering long-term human-AI relationships. So in this case, a strong regulative approach might be somewhat relevant because we have the same risk landscape that is associated with such traditional standalone AI companions, meaning risks of manipulation, increased self-disclosure of private information, early exposure to sexual content, privacy risks, and many other risks that we can see in the Character.AI and Replica use cases. So maybe the law should reflect this differentiation by providing a carve-out for those context-restrained AI companions. And we can see this, for instance, in California, where bots that are part of a video game are not covered by the companion definition if they are restricted to game-related topics, so they cannot talk on matters that are personal to the users, and if they are not able to engage in risky topics like sexuality, mental health, and so on. So maybe that would be a more differentiated approach that lawmakers could take. And I believe most US states that discuss such laws already implicitly have this differentiation. You can also see this, for instance, with New York's approach, which also only covers chatbots that foster emotional, long-term human-AI relationships.
Right. Yeah, that makes total sense. I see that you're constantly alluding to maybe two categories of character and AI characters, right? How would you like just briefly state how you would categorize each one, like how you would label each category, and what exact technical parameters do you think that regulators could use to differentiate each one? Because I think some of them are very obvious. I think if you go and speak to an NPC in a game like Skyrim, it can be very obvious that it's not a dangerous and it's not a risk, but some might fall more in a gray line. Like, what technical parameter do you think regulators could stand by that would assure that the risk is being mitigated?
Yes, as I said, the broad categories are the gameplay-focused video game AI companions that are restricted to gameplay-related topics, and the emotional video game AI companions that encourage the formation of long-term emotional human-AI relationships. And from a technical perspective, I believe the first parameter that is quite significant is the memory capability of the chatbot. If the chatbot, by technical necessity, always forgets the player after each session, then it is not able to really facilitate potentially dangerous emotional bonds. So that is, I believe, one requirement that chatbots would have to meet to fall into the emotional video game AI companion class. The other parameters that I would deem crucial is that the character engages in unprompted emotional questioning. So it does not only react to prompts by the player, but actively asks the player about emotional and personal topics. So it's a proactive chatbot. And I believe it's also crucial that it really goes beyond the game and discusses emotional aspects of the player's life. So proactively personal topics, and it must have a memory capability. So in the end, it boils down to the safeguards that the publisher implements. So if the publisher can ensure that the NPC is unable to really get into personal details of the player's life and emotional state, then in my opinion, it should be classified as a gameplay-focused video game AI companion. But if such safeguards are not implemented or work insufficiently well, or if the publisher actively encourages such emotion-based responses and interactions, then I believe we are in a more risky category and must classify the chatbot as an emotional video game AI companion. Maybe as an example of that category, imagine a game like Baldur's Gate 3 where you have romanceable characters, and unlike now where we have only scripted dialogue options, we now have this character connected to a GPT interface and would be able to discuss emotional or romantic topics. Then I believe we are in the emotional video game AI companion category and must implement a stronger regulative measures.
Right. And that phrase really reminded me of the movie Her.
Yeah, absolutely.
So, yeah.
I actually watched the movie earlier this year, and it's quite astonishing to see how many of the issues related to AI companions that we can see in real life now actually predicted in that movie. I believe it's an amazing watch for everyone interested in AI companions and regulative and ethical aspects of human chatbot interactions in general. It's absolutely great.
Yeah, it's incredible. That movie becomes more relevant every day.
Yeah.
So the Chat Act would apply only to companies making products or selling products within the US. What do you think the industry reaction would be, like the video game industry reaction would be for US video game makers and then European and Asian-based game makers? What do you think that maybe outside of the US, they would maybe try to avoid the US market because of this? What do you think the reaction could look like?
It's difficult to assess. What we can see right now in the US, at least, is that the tech lobby is heavily rejecting the law and tries to criticize it as much as possible, basically mainly because the scope of the law is too broad and video games and so on would be covered. And I believe this reaction would be similar for companies in the EU and Asia. Because as soon as they want to enter the US market, they would fall under the law. And I believe at least large multinational publishers might be able to comply. So they could, I don't know, implement US-specific game versions that either adapt or restrict the AI companion features, or they could simply build infrastructure that is needed to comply with the law's age verification and content moderation obligations, implementing suicide security protocols, and so on. And maybe even implement this on a global scale so they don't have to make region-specific game versions. But for smaller publishers, I believe the situation is very different. Independent developers often lack the financial resources or technical capacity to sufficiently track users' age, manage parental consent, or actively monitor the NPCs' interactions in a data protection secure way. So if even relatively low-risk gameplay-focused video game AI companions could trigger these compliance burdens, I believe the US market could be effectively off limits for these smaller independent studios. And the broader consequence that I fear could follow the law is that the act might consolidate the video game AI companion industry around large multinational publishers, which would in turn limit the experimentation and innovation in AI-driven storytelling. So that is one of the main problems that I see. And that would obviously also lead to uneven global gameplay experiences because studios would smaller studios would either have to modify games for the US market or decide to avoid releasing games with such features entirely. So I believe that the risk is that the Chat Act exports US regulatory burdens worldwide, while only achieving limited gains in player safety, at least regarding gameplay-focused video game AI companions.
Yeah, that makes a lot of sense. I think that this also could help, in a way, big video game publishers to acquire smaller players because they just can't handle the new financial burdens that this compliance would require. And I mean, we like recently, you probably saw that Netflix acquired Warner Brothers. I mean, I think it's kind of a similar tendency would begin to happen in video games because of laws like this that would just make the like publishing as an independent studio quite unfeasible, right?
Yeah, and it would actually prevent many studios from coming up with experimentative gameplay ideas. I believe there was 2 years ago, for instance, a horror game where the player sort of an escape room experience where the player would have to escape a flat with an obsessive girlfriend. It was some sort of anime game, and the NPC was based on a GPT interface. So the player would have to negotiate on a sort of puzzle-based, in a puzzle-based way with this AI character and try to manipulate the character to let the player out. And such small, funky ideas, I believe, are impossible if the regulatory burdens are so strict and the potential penalties so high that small studios, I believe it was one person who developed this game. It's a problem, at least.
Beyond like increasing costs for game developers, what broader industry risks? And in terms of industry, I'm talking more about the AI industry, not so much the video game industry. Do you think could emerge due to this over-regulation?
It's not that easy to answer. I believe in general, regulating AI companions is ethical, an ethically very, very important goal. Potentially, the parasocial bonds that emerge in such interactions are one of the most important ethical questions surrounding generative AI today. But if we do not take an empirically interdisciplinary informed approach towards regulating these systems that considers the social functions and relational dynamics at place, we might risk taking a too strict approach that would cover use cases where the risk profile is quite low, which in turn would hinder innovation and creativity, and potentially take away many of the opportunities that also come with such systems. For instance, having companionship whenever you need it, having someone you can vent to without having the fear to be judged. So there are many opportunities that these chatbots create, and we should be very careful to find the right balance between enabling these opportunities, but also addressing the risks that are associated with them. I believe it's the most complicated thing about AI governance and regulation, to strike the right balance between innovation and protecting sort of fundamental rights and freedoms of the persons using these systems.
Right. Yeah, I totally agree. That reminded me the other day, I was watching an interview from Dario Amodei, the Anthropic CEO, and he was talking about that, about the importance of really striking a good balance with AI regulation, because and your blog post kind of reminded me of this, that if there is over-regulation, it can also lead to it can also amplify the voices that are against all regulation, because they'll just say, hey, look at the chatbot, it destroyed the video game industry. It will be like a really strong example for anti-regulation, and I mean, for the future, that's a very dangerous road to go down.
Exactly, and the problem is that the technology is developing so fast and dynamically that it's incredibly difficult for lawmakers to find laws that predict these developments and strike the right balance. We can see it with the AI Act, which barely governs generative AI applications because the lawmakers didn't really foresee the risks associated with these systems. So perhaps the future is not a detailed systematic, dogmatic approach towards law, but maybe we sort of need broader principles comparable to, I don't know, Article 5 of the GDPR that then have to be detailed by authorities. So it will be really interesting to see how lawmakers deal with these dynamic developments. But the US approaches, I believe, are interesting as a model law, because you have all these different state initiatives that propose very different regulative approaches and philosophies. And for jurisdictions like the EU, we now have the opportunity to see how this all develops, how this works in practice. And perhaps we can use that as inspiration and as a way to improve our regulation, especially now that the EU lawmakers are discussing stricter obligations for AI companions. Maybe that's also a nice aspect.
Right. Yeah, that totally makes sense. I mean, I think that's pretty much all I wanted to discuss. Is there anything else that you would like to add? Any concluding thoughts? And also, if you have any new and upcoming projects that you are excited about.
Maybe there's one project I want to briefly touch upon, because I believe it's a very important one for human AI interaction. Here at Bucerius Law School, Greta Spaczynski and I are currently researching end-user transparency in AI companion interactions. We are sort of taking a comparative law approach, looking at the EU's AI Act alongside all these emerging US frameworks that specifically address AI companions. And what we are trying to find out is how effective are these transparency rules in practice? Because what we know from psychological research is that, according to the ELIZA effect, people tend to project human emotions, intentions, empathy onto chatbots, and even in cases where they are fully aware that they are not interacting with a human, but with a machine. So what we are trying to assess is to what extent these proposed and currently applicable transparency obligations are actually capable to meaningfully mitigate the risks that are associated with AI companions, especially regarding emotional dependence and so on. Because just if we look at the chat act, we can see that these periodic disclosure, you're interacting with an AI and not a human, are always part of the core obligations enshrined in the law. And if you look at the psychological research, there are questions around whether this really helps, or maybe even leads to the opposite effect of people trusting the AI more and are more prone to disclose potentially private information. So that is what we're currently working on. There is a preprint on SSRN right now that compares the approach under Article 50 AI Act with the transparency requirements under New York's AI companion regulations. So maybe that is interesting for those that want to find out more about AI companion transparency. It's titled, I believe, Hot Singles in Your Area, Maybe Chatbots, comparing EU and New York approaches to AI companion transparency. Maybe one of the benefits of the topic, you can have a lot of funnier titles.
Really interesting and really relevant work that you're developing. So yeah, I'm excited to see how that research comes up, and I will definitely check out the current paper that you have up.
So thank you so much. Yeah, we're also excited to find out what our conclusions will be. We're also in exchange with psychologists and hoping to get some insights on the non-legal perspective, because I believe AI regulation is a topic that you cannot address solely based on a doctrinal legal perspective. You must consider non-judicial research, psychology, computer science, and so on. So I believe that will be very helpful for our research.
Yeah, definitely. I think it's such a broad spectrum of like research that can be valuable for AI research, because it feels like AI is really getting into kind of everything. It's like interweaving into all aspects of life, and as you say, like just focusing on doctrinal and legal research doesn't work in this case.
Yeah.
There are definitely many more fields of study have to be included.
Yeah, absolutely.
Well, I think that's pretty much it. Thank you so much, Tarmio, for participating today. And any concluding thoughts you want to say?
Actually, just thank you so much for having me and giving me the opportunity to share some part of my research. There's also some time next year an extended paper coming up about video game AI companions under different regulations. So if anyone is interested in that, feel free to check it out once it's ready. It will address the AI Act and California's AI companion regulation, as well as New York's law, and at least that's the plan. Also briefly touch upon the Chat Act, as well as the Guard Act, which is another federal proposal on regulating AI companions.
Amazing. Thank you.